The Consolidated Omnibus Budget Reconciliation Act of 1985 is a law passed by the U.S. Congress on a reconciliation basis and signed by President Ronald Reagan that, among other things, mandates an insurance program giving some employees the ability to continue health insurance coverage after leaving employment. COBRA includes amendments to the Employee Retirement Income Security Act of 1974. The law deals with a great variety of subjects, such as tobacco price supports, railroads, private pension plans, emergency room treatment, disability insurance, and the Postal Service, but it is perhaps best known for Title X, which amends the Internal Revenue Code and the Public Health Service Act to deny income tax deductions to employers for contributions to a group health plan unless such plan meets certain continuing coverage requirements. The violation for failing to meet those criteria was subsequently changed to an excise tax. Although this statute became law on April 7, 1986, its official name is the Consolidated Omnibus Budget Reconciliation Act of 1985. Because of a discrepancy between the official name of the Act and the year in which it was enacted, some government publications refer to the Act as the Consolidated Omnibus Budget Reconciliation Act of 1986. The Act is often referred to simply as COBRA. Provisions: as originally enacted, Title X of the Act provided that a qualifying employer will not be permitted to take a tax deduction for its health insurance costs unless its health insurance plan allows employees of the employer and the employee's immediate family members who had been covered by a healthcare plan to maintain their coverage if a qualifying event causes them to lose coverage. However, the legislation was subsequently amended to instead impose an excise tax upon an employer whose health plan fails to satisfy the applicable rules. A qualifying employer is generally an employer with 20 or more full-time equivalent employees. Among the qualifying events listed in the statute are loss of benefits coverage due to the death of the covered employee. An employee loses eligibility for coverage due to voluntary or involuntary termination or a reduction in hours as a result of resignation, discharge, layoff, strike or lockout, medical leave, or slowdown in business operations. Divorce or legal separation that terminates the ex-spouse's eligibility for benefits. Or a dependent child reaching the age at which he or she is no longer covered. COBRA imposes different notice requirements on participants and beneficiaries, depending on the particular qualifying event that triggers COBRA rights. See DOL.gov's FAQs for employers about COBRA continuation health coverage. COBRA also allows for coverage for up to 18 months in most cases. If the individual is deemed disabled by the Social Security Administration, coverage may continue for up to 29 months. In the case of divorce from the former employee, the former spouse's coverage may continue for up to 36 months. In the case of death of the former employee, the widow's coverage may continue for up to 36 months. COBRA does not apply, on the other hand, if employees lose their benefits coverage because the employer has terminated the plan altogether or if the employer has gone out of business. In cases where COBRA does not apply, some states have stepped in with state health insurance continuation laws, usually called mini-COBRA laws, which help employees continue their health insurance when federal COBRA does not apply. COBRA does not, unlike other federal statutes such as the Family and Medical Leave Act, require the employer to pay for the cost of providing continuation coverage. Instead, it allows employees and their dependents to maintain coverage at their own expense by paying the full cost of the premium the employer and the employee previously paid, plus up to a 2% administrative charge. According to the U.S. Department of Labor, the coverage you are given must be identical to the coverage that is currently available under the plan to similarly situated active employees and their families. You will also be entitled, while receiving continuation coverage, to the same benefits, choices, and services that a similarly situated participant or beneficiary is currently receiving under the plan, such as the right during an open enrollment season to choose among available coverage options. You will also be subject to the same rules and limits that would apply to a similarly situated participant or beneficiary, such as co-payment requirements, deductibles, and coverage limits. Employees and dependents can also opt for a lesser form of coverage, for example, to choose continuation coverage under a plan that only covers the employee, but not his or her dependents, or that only provides medical and hospitalization coverage and does not pay for dental work, if those options are available to covered employees. Employees and dependents lose coverage if they fail to make timely payments of these premiums. Employers are required to inform employees and dependents upon loss of coverage, in writing, by at least 15 days before the coverage ceases. Coordination of coverage. An individual covered under COBRA may also be covered by another group health plan or Medicare as long as either of two conditions is met. The other coverage was in force as of or prior to the coverage under COBRA. The other coverage is subject to pre-existing conditions, exclusions or limitations. Subsidy under federal stimulus. Only 10% of Americans eligible for COBRA insurance in 2006 used it, many because they were unable to afford to pay the full premium after their job loss. While some employers may voluntarily help subsidize or fully cover the cost of COBRA insurance as part of a termination or exit package, it is more common for the ex-employee to cover the entire cost. The American Recovery and Reinvestment Act of 2009, as signed by President Barack Obama, includes a 65% subsidy to employees for COBRA-enabled insurance for up to 9 months after an involuntary termination. An employee is eligible for this subsidy if the termination of employment was involuntary, the terminated employee has no other group-sponsored health insurance option, and the terminated employee is otherwise eligible to enroll in COBRA. If the employee has an adjusted gross income in 2009 over $125,000 if filing as single, then the subsidy will be recaptured in a phased manner from the employee through the tax system. Termination of employment must have occurred between September 1, 2008 and December 31, 2009. Specific provisions and responsibilities may differ in the state-specific mini-COBRA plans for employers with fewer than 20 employees throughout half of the previous calendar year. Those employees who are eligible for the ultimate benefits of this subsidy are referred to as assistance-eligible individuals. Employers subject to federal COBRA are required to notify terminated employees of their potential rights under ERISA by sending a series of notices, provide a method for qualified AEIs to enroll, pay the full amount of the premiums and seek reimbursement of the 65% subsidy by including it in the employer's quarterly federal tax return. This act was signed into law by President Barack Obama on February 17, 2009. On December 19, 2009, President Obama signed into law the Department of Defense Appropriations Act, 2010, which made several amendments to the COBRA provisions of the American Recovery and Reinvestment Act of 2009. The act extends COBRA subsidy eligibility to employees who lost their jobs due to no fault of their own between January 1 and February 28, 2010. The 9-month subsidy period was also expanded to 15 months. On March 3, 2010, President Obama signed into law the Temporary Extension Act of 2010. The act extends COBRA subsidy eligibility to employees who lost their jobs due to no fault of their own between March 1 and 31, 2010. In addition, employees who lost group health insurance due to reduced work hours on or after September 1, 2008, followed by involuntary termination between March 2 and March 31, 2010, will now be eligible for the COBRA subsidy. The Continuing Extension Act of 2010 extends premium assistance for COBRA benefits through May 31, 2010. As of June 2010, an extension of COBRA's premium assistance has not materialized, and attempts by congressional members to include such provisions have been dropped. As of June 1, 2010, all newly unemployed workers must pay full coverage costs as determined by their respective plans. This is due in part to conservative Democrats in Congress who have expressed concerns about treating some unemployed workers differently from others, such as people priced out of the private insurance market. A number of Senate Democrats expressed concern about this situation and have introduced legislation to expand COBRA coverage to people who become unemployed through November 2010, but such legislation did not pass in 2010. Similar state and local legislation, 41 states have legislation similar to federal COBRA requiring employers to allow employees and their dependents to continue their group health insurance coverage following certain qualifying events. California's legislation only applies to non-government employers with a group health insurance plan with fewer than 20 employees. District of Columbia. The District of Columbia's Continuation of Health Coverage Act of 2001 applies to employers with a group health insurance plan with a situs in the District of Columbia and with fewer than 20 employees. Coverage must be offered to be extended for a period of 3 months following the date that coverage would have ended. Maryland's legislation only applies to employers with a group health insurance plan with a situs in Maryland and with fewer than 20 employees. Maryland law requires that continuation coverage must be offered to an employee who lives in Maryland, who had coverage from the employer for at least 3 months, and who either resigns or loses employment due to no fault of their own. Continuation coverage must also be offered to the former spouse and dependent children of an employee after a divorce. One exception to the 18-month rule is that coverage may end for the former spouse upon the former spouse's remarriage. Continuation coverage must also be offered to the surviving spouse and dependent children of an employee who dies. The employee must have resided in Maryland and had coverage with the employer for at least 3 months prior to death. In all cases, continuation coverage must be offered for 18 months, with the exception that a former spouse's continuation coverage ends upon remarriage. Virginia's legislation applies to employers with a group health insurance plan, other than an HMO plan, and with 20 or fewer employees. Employers must offer continuation coverage to employees for 12 months. The legislation does not apply to employees who did not have coverage from the employer for at least 3 months prior to the qualifying event. Notes. References. External links: U.S. Department of Labor, COBRA FAQs for employees, Employee Brochure, Department of Labor. Other resources: Department of Labor, COBRA Insurance Direct. Learn more about COBRA Insurance, COBRA Insurance Guide. Information about COBRA, COBRA Insurance Information Center, Library of Congress. Thomas Summary of the Act. General information from the Centers for Medicare and Medicaid Services, COBRA Insurance Information.